The stakes couldn't be higher for Joshua Mays, a young man who's walking a razor's edge between freedom and prison. On probation for attempted burglary of a habitation, he was given a chance most defendants dream of, keeping a felony conviction off his record. But the question now is, did he squander that opportunity? Missed reports, unpaid fees, and skipped programs have put him right back in front of a frustrated judge.
Because that's something that is really frustrating to me, is that all of a sudden people start doing what they're supposed to be doing when they know they could go to prison. It's ridiculous. You have hardly any criminal history. You got into some trouble as a juvenile. You haven't been in much trouble at all. And you're not taking advantage of keeping this conviction off your record. All right, so you're Joshua Mays. And Mr. Mays is on probation for burglary of a habitation, was placed on a deferred probation back in September of 2021. And that was a 10-year, no, it wasn't. It was a 3-year deferred probation. There was a motion to adjudicate filed. We were here before. Mr. Mays pled true to failure to report and a failure to pay court-assessed fees. Let's see. Hold on a second. Let me go back. So it looks like, do you want to put on any evidence with regard to counts 2 and 3, the education program and the MRT?
Yes, I do, Your Honor.
All right. You can call your first witness, Mr. Nichols.
You swear to me.
Yes. Would you please raise your right hand, ma'am? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
Ms. Joseph, how long have you been supervising Mr. Mays?
The probation officer takes the stand, confirming what the court already suspects. Joshua hasn't completed his GED, hasn't verified participation in classes, and most damaging of all, hasn't even started the moral recognition therapy program, a key part of his probation conditions. This paints a troubling picture. Despite opportunities, Joshua appears to be dragging his feet.
Since April of 2022.
And during that time, was he ordered to participate in the GED?
Yes.
Has he completed that?
No, sir.
Did he provide you the verification that he was participating?
No, sir.
Are you aware of the issue he outlined in the letter to the court that he claims he made progress while at ISF, but those credits didn't be accepted by the program? Or do you know what that issue is?
I read it in his letter.
Do you know anything else about that? Whether or not they would take those credits or not?
No, sir.
Okay. But did he give you the verification that he's been participating in that GED program? Okay. And moving on, was he also ordered to participate in the moral recognition therapy program?
Yes.
And has he participated in that?
No, sir.
What level of participation has he done in the MRT program?
He has not even begun to start it. However, while we were waiting to come to court for this, they have since discontinued for a period of time until they can hire someone to offer the class. And we will again, but it's just worthwhile to note that while we were waiting, somebody retired, and so they had to hire someone else.
At what point did they suspend the MRT program?
March of this year.
Okay.
March or April.
But during the years he's been on probation, you're not making
Right.
progress.
No, sir.
Okay. And so should he be, that program you believe will be available in the future?
The testimony reveals another troubling truth. Joshua has absconded 3 times. In probation terms, absconding means disappearing from supervision, essentially going rogue. Judges consider this a major red flag, often the very behavior that triggers revocation. Yet despite this, his officer admits Joshua has maintained employment and shows respectful demeanor when reporting. Here lies the contradiction: a man who can hold a steady job but can't keep steady compliance.
He will.
Is there anything else contained in your pre-sentence investigation you want to bring to the court's attention? Okay. Thank you. I'll pass the witness.
Thank you, ma'am. Mr. Kimler?
Have you checked the ISF facility to see if they have a GED program?
They for a fact do, sir.
Did you check to see if he participated in it? Did you check to see if he participated in it?
Didn't mention anything about it until after his release from the facility.
And my question is, did you try to
No,
check?
I didn't have a reason to. He didn't say that he had participated in that until after his release.
No, I'm not trying to put you in a defensive posture. I'm just wondering if there's been any kind of independent attempt by the probation department to corroborate what he said about participating in the program while in ISF.
He didn't present any documentation.
So my question-
I didn't check with ISF to verify what he said.
But just to be clear, ISF does in fact have a GED program.
They do.
Has he maintained employment while he's been in probation?
He has.
So lack of a GED, and again, the GED is worthwhile on its own merits, but it doesn't seem to have impacted his ability to maintain employment, the lack of a GED. He's been able to maintain employment without a
Yes.
GED. So you would say he has worked faithfully to suitable employment.
He has.
What is the moral recognition class? Is that how you say it, recognition?
Yes, sir. That's how you say it.
How many sessions is that?
8.
Over a week, once a week or once a month?
They present one lesson each week until they have finished the course.
And it's a progression, then they're different classes. It's like a progression from 1 through 8.
There's
So you
a
would have to-
book that they have to purchase, and they do each chapter in the book until they have completed the book.
In sequence, right?
Yes.
In sequence. So he would need at least 8 weeks to complete that if you took one session per week, is that right?
Yes, sir.
Has he maintained a proper demeanor with you?
Yes, sir.
And as far as his reporting, he certainly hasn't become an absconder, is that right?
He's been an
has-
absconder 3 times.
Well, I mean, as far as what she's concerned, has he maintained contact with you or has he become?
Since his release from custody, yes.
We now hear the hesitation from the probation officer. Instead of firmly recommending revocation or continuation, she defers entirely to the judge. This is unusual. Normally, officers provide strong recommendations, revoke or extend probation. But here, the indecision underscores the complexity of Joshua's case. He's not failing in every area. He's simply inconsistent. The officer cautiously suggests extending probation by 1 year to give him another chance at his GED and therapy.
He's maintained
Yes.
contact and reported this directly. Uh, in your report, you seem to indicate a willingness, a reluctant willingness perhaps, to have him continued on probation. Would you agree with that?
I hesitated to recommend that he be continued.
Did you recommend that or not?
My statement was that I hesitate to recommend should the court decide. So I'm really leaving it up to the court because I don't want to make a recommendation.
So you don't have a recommendation. So you're not recommending that he be revoked, but you're not recommending that he be continued. Is that true? But if the court were to see fit to continue him, then you would suggest extending him a year to give him an opportunity to complete the GED, pay his fees, and I guess at this point, once you all get somebody hired to do the moral recognition therapy class. Is that right?
Right, and I also recommend he come back to verify.
Every 6 months.
Yes,
Sure.
because he has a habit of not reporting.
And of course, you could notify the court about that. You could schedule a hearing and holding this in advance. Right, these allegations.
I'm not holding, yeah. Okay, go ahead.
I was just, that's what,
Yeah.
The judge takes a deeper dive into MRT, explaining its purpose, teaching offenders moral standards and ethics to prevent reoffending. It's meant to reshape decision-making from the inside out. Yet Joshua has skipped this program entirely, despite multiple chances. But here's the shocking twist. Joshua has not committed any new crimes during probation. That fact carries serious weight. In many courts, avoiding new charges is the ultimate test.
What's the purpose of the moral recognition? What's that directed to achieve with probation?
It's to teach them moral standards, have a sense of ethics and values, as well as other life skills.
So what is it? Keep them from reoffending? Would you agree?
Yes,
Be a good citizen.
yes, sir.
Has he reoffended since he's been on probation?
No, sir, he has not.
That's, I have another question concerning those allegations. Your Honor.
Thank you. So concerning those allegations, number 2 and number 3, I am going to find those true, that there's sufficient evidence to find counts 2 and 3 true. And so what the ISF that he went to, it doesn't say if it was cognitive or, do you know, Mr.?
It would have been a combination of both at the time. It was substance abuse cognitive intervention tracks because he tested positive for THC.
So he went, back then you could do both. You can't do that now. I don't think.
Based on what they're offering at this point. But yes, he went for cognitive as well as substance abuse.
Okay.
And we're referring to the admin hearing from January 15th of 25, Your Honor.
Thank you.
Indicates that on January 12th of 2024, that it was recommended and approved that he, or on the 23rd, sorry, that he was successfully complete ISF cognitive and substance abuse tracks. So is that a 6-month program?
The court clarifies the record. Joshua's charge is attempted burglary of habitation, a third-degree felony, not burglary as previously stated. This distinction matters. Attempted crimes often carry lighter penalties, and the correction highlights how even technical errors in paperwork can have lasting consequences in criminal cases. Prosecutors quickly amend the record, ensuring the legal foundation of the proceeding is accurate.
It is a 90-day program.
So most,
I think they changed what they offer now, but it's a substance abuse now, and then it's a cognitive, and then relapse. At this time, they combined substance abuse and cognitive tracks.
I think you wanted to address the court to your Honor. He has written the letter. Sure.
I've read the letter as well. Mr. Mays?
With the transcripts, I have them in my folder. When I went up to the GD to work with him, the lady said that she couldn't take them, so I started doing GD on my own, like on my phone. I got work, I complete the classes on my own. I just haven't brought it to attention, but I have been doing a different classes and stuff on my own.
Why didn't you bring it to her like you're supposed to?
No, so
Okay.
she just brought it to her.
Mr. Nichols?
Judge, I know that this is a tough call for the court. These aren't the worst allegations we've ever seen, but he's also in zero tolerance and has been several times sanctioned, both in jail and with the ISF programs. And still, after only 3 years on, not even 4 years on probation, Judge, we're back yet again. It's really a test of zero tolerance at this point, Judge, because that's what he was ordered, was no problems whatsoever. And missing 3 months of reporting is a pretty big red flag.
Let me look back at something real quick. Also, before I want to make sure everything is saying that it was burglary of a habitation, but at some point, it looks like, at least on the old PSI, it was attempted burglary of a habitation, a third degree. I want to make sure all the administrative hearings, the motion to revoke, everything says burglary of a habitation. I want to get that cleared up.
Your Honor, actually, I think the indictment is attempted At least I'm looking
Is
at the
it?
indictment that's captioned attempted burglary of habitation.
Okay, so the burglary of a habitation, do you want to make an oral motion to amend at least this motion that we're talking about today?
Yes, Your Honor, I will change burglary of habitation to attempted burglary of habitation, comma, a third-degree felony.
All right. So we're talking about a third-degree felony.
The judge takes stock of Joshua's journey. On one hand, he's been irresponsible, missing appointments, and only trying to comply when court dates loom. On the other, he's employed, crime-free, and showing glimpses of maturity. The judge describes it as a glass half full, glass half empty situation. This is a rare moment where we see the internal struggle of the bench, punish to protect the community or rehabilitate to save a man from prison.
So, Mr. Mays, the problem is that you just like to do what you want to do when you want to do it.
Yeah, man.
And
Good argument. The thing I just wanted to say is it's kind of glass half full, glass half empty thing. If you want to look at somebody that we're trying to return to the community as a productive citizen, which is the goal versus sending another person to the penitentiary, he has maintained employment. And he's had some, I guess, hiccups on probation as far as reporting, but he hasn't reoffended. He's employed. It seems like he is making a positive contribution to society at this stage. I don't really see where the interest, me personally, the interest of the community would be service to send another person to the penitentiary when you are making enough progress. And again, it's marginal, but looking at the totality of the circumstances to keep working with him to hopefully keep him out of prison where he can keep employed.
well, here's my thoughts, Mr. Mays. You're not going home today.
The judge delivers a stunning ultimatum. Joshua isn't going home today. He has two options, prison or entry into the ISF Cognitive Track Program. This is no idle threat. ISF, or Intermediate Sanction Facility, is essentially a lockdown program designed to correct behavior without sending someone to full prison. It's a last chance program, structured, strict, and unavoidable. The judge's frustration is palpable. You don't get to be good only when court is near.
That's not happening. You're not going to walk out of here today. You're either going to get revoked to go to prison, or you're going to go to the cognitive track of ISF. Because somewhere along the path, you did not pay attention and you haven't learned from whatever treatment you've had before to make better decisions. You've been put on zero tolerance. You've been told don't miss another appointment. You have now 3 different times been given these opportunities and have not taken advantage of them. I don't disagree with Mr. Kimler. You haven't reoffended. You're not testing positive all the time. You're not doing those things, but you don't get to choose when you go to probation, when you don't, and you don't get to all of a sudden be really good at it when you have a court date coming up. Because that's something that is really frustrating to me, is that all of a sudden people start doing what they're supposed to be doing when they know they could go to prison. So my thought, I mean, you think it's ridiculous. You have hardly any criminal history. You got into some trouble as a juvenile. You haven't been in much trouble at all. And you're not taking advantage of keeping this conviction off your record. And that's going to be on you, not on me, if this happens again. Because I have no doubt if I do what I'm thinking about doing and we're back in here again, Mr. Nichols is going to point out to me how many times I've given you an opportunity. Do you understand? There will not be another opportunity. I'm going to find that you entered your pleas of true to counts 1 and 4, freely and voluntarily. Find those counts true. Again, find that.
And then comes the hammer. Joshua's probation is extended by 3 more years, 1 for each time he absconded. Instead of ending his probation, he now faces a longer, stricter road ahead, including mandatory completion of the ISF cognitive track. The judge makes it clear no more excuses, no more missed meetings. The next violation means prison. For Joshua, this is a mixed verdict. He dodges prison today, but at the cost of 3 more years under the watchful eye of probation.
There was sufficient evidence to find counts 2 and 3 true and find those true. I'm going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to add an additional 3 years to your probation. So you could have already been done, but instead you have 3 more years. And that's the 1 year for every time that you've been an absconder. So that's what you're going to have to do at this point. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. You need to take advantage of that program, learn to follow the rules, all the rules, get out, and you still have an excellent opportunity. But if you're back in front of me again, I'll see all of this. I'll probably wonder at the time what I was thinking today, but you will not get this opportunity again. Do you understand? 1 missed meeting. We're not going to do 2 or 3 missed meetings. We're not going to get to absconder status again. You miss a meeting, I want to hear about it in an administrative hearing. There's going to be a motion to revoke, and you're going to go to jail.
Your Honor, since you've learned how to track.
What a dramatic turn of events. Joshua Mays walked into court facing the very real possibility of prison, yet walked out with an extended probation sentence and one final chance to prove himself. The judge's frustration was clear. Probation isn't about convenience, it's about compliance. For viewers, this case highlights a burning question: how many opportunities should the justice system give before enough is enough?
And I said we rescind the moral recognition therapy. It seemed to be redundant.
Nope. Kind of seems like he needs some redundancy. Might help if he gets out and then has more to reinforce what he learned. So no, I'm not going to do that. All right. I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Kimler about that. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor. My phone.